Hamish. This is Stan, and welcome to another episode of Civil Banter. We are two civil litigators at Nelligan Law, helping people through injuries, insurance fights, and all of life's legal curveballs.
All right, welcome to episode 16, Legal Own Goal, the Law of Contributory Negligence. So I guess the title tells you what it's about, like all good titles should, but this is contributory negligence we're going to be talking about. So if you've been in some kind of misfortune, some kind of accident has befallen you, is it all your fault? Is it all their fault? Whose fault is it? We're going to talk about that. But before we do, we're going to bring back another segment from our earlier days on the podcast. If listeners were around for last episode, they would have heard me embarrass myself on the reasonable stand segment. And this is my turn to see if I can flummox Hamish with a segment called You Ought to Know.
Yeah, this is your chance to punish me for my unreasonable cases I present to you on reasonable stands. So you ought to know, for the listeners who haven't heard this segment before, what's it all about?
Well, it premiered back in episode 6. You can go back if you want. But basically, this is a segment where I give a case to Hamish. I sum it up without giving him the conclusion about whether or not the person who was involved in this was injured as a result of the use or operation of a motor vehicle.
Mm-hmm.
And if they were injured as the result of the use or operation of a motor vehicle, then they would be entitled to accident benefits. And we did, again, 2 episodes on accident benefits.
You're probably getting sick of hearing us talk about accident benefits.
But they're really important, and nobody really thinks about them or knows about them.
Mm-hmm.
And so in this case, we find out, was it a car accident? And if it was, then the person can access the accident benefits. They can go to physio. They can do whatever they need to do. And if it was not, well, then they're stuck with just a regular tort lawsuit only.
Mm-hmm.
So in this game, I'm going to present Hamish with the facts. And in this case is a pretty new one. It's from January 2026.
Okay.
All of the cases these days for these issues go to the License Appeal Tribunal. And this is the case of Gadomski and Definity, 2026, Canley 8159. The plaintiff, Gadomski. Give you some facts here. So the applicant, Mr. Gadomski, was working for Uber,
Mm-hmm.
delivering food on the night of April 24, 2025. While driving through a plaza at night, he was delivering food to the customer who was waiting in a parked vehicle.
This sounds like it's going to be used in operation so far.
I mean, both parties are in cars.
Yeah.
I'm wondering why somebody in a car needs to order Uber Eats, but we're going to park that for now and forget about it. But it did bother me. I thought, you're in a car already, my friend. Just go into the drive-thru. Anyway, as Mr. Gadomski's driving to look for this delivery, he gets a green laser in the eye from the person who he's delivering the food to. I guess to tell him, hey, I'm over here. This is where you need to deliver your food to.
Wait, you don't shine green lasers in people's eyes when they're delivering you food?
As a general practice, I do not shine green lasers into anybody's eyes. But I understand it's a thing, I guess. I've heard about airline pilots getting the laser treatment on landing, which is insane.
Mm-hmm.
But in this case, I guess this guy was tired of hanging out by the airport. He thought, I'll just laser my Uber driver. Nuts. So the driver allegedly suffers an eye injury as a result of the laser. I don't know what kind of laser it was, but allegedly suffers an eye injury. To be clear, there was no collision, there was no vehicle malfunction, and there was no physical contact between the vehicles. He felt so strongly about it that he called the police, and the police investigated, and no charges were laid.
Mm-hmm.
They came to the conclusion that the person shining the light was trying to be helpful.
Okay.
All right. So we look at this. What is the test? How do we decide what is and is not an accident? So that's under section 3.1 or 3 subsection 1. And an accident is defined as an incident in which the use or operation of an automobile directly causes an impairment or directly causes damage to any prescription eyewear, denture, hearing aid, prosthesis, or other medical or dental device. The court in this case, the tribunal in this case made reference to earlier decisions from a court. I'm not going to bother you with the names of those decisions, but they refer to some earlier case law about the test we use to decide whether or not there's an accident. And they've said there's a two-part analysis you have to do: the purpose test and the causation test. Okay, so the purpose test is a determination of whether the incident resulted from the ordinary and well-known activities to which automobiles are put. Seems pretty straightforward. In this case, delivery car.
Delivering food and receiving delivery food.
The causation test requires a determination of whether the use or operation of the motor vehicle directly caused the impairment. All right? So let me give you the position of the parties. This will help you in your analysis.
Can I just one clarification point? Were both parties in their respective cars at the time the laser was shown?
Yes. The guy who's getting the food delivered to him did not open the window and wave, which seems a lot easier. Didn't get out of the car and wave. Felt this was the best option available to them. Let's laser my driver in the face while he's driving around the parking lot. They're actually quite lucky he didn't crash the car.
Yeah.
Which I'm going to spoiler here. If he did, that would have certainly been the use or operation of a motor vehicle. Okay, so the plaintiff, the applicant, in this case, he claimed that the incident was an accident under the legislation because it occurred during the ordinary use of his vehicle for food delivery, and it would not have happened but for driving the vehicle. He submits that the but for test is satisfied because the incident resulted from the ordinary well-known use of the vehicle, and the other person was also in a vehicle. So there's two people, both of them are in vehicles. The applicant says that there was an unbroken chain of events that would not have happened but for his use of an automobile, and that the use of the other vehicle was not incidental either. The other party, if they were at their house, would not have, Sean presumptively greeted this man with a laser. So he says, it was only because I was delivering to somebody else in a car that this lasering happened. If I had dropped Uber Eats off at their house,
I think they still would have lasered
I
him.
think this guy was really into lasers. And I think you're not wrong. But that was the position the applicant took. Look, like this wouldn't have happened if I was delivering to his house. He wouldn't have lasered me, although I guess he would have had the address, right, as opposed to just a busy parking lot.
Yeah.
The applicant further took the position that, you're going to like this one. It's a bit of a stretch. I like the moxie of applicant counsel on this. So took the position that comprehensive vehicle insurance includes missiles or flying objects as possible causes of an accident. He further submits that if a vehicle is covered against flying objects, then the occupant of that vehicle should also be covered. I agree with that.
Mm-hmm.
This is where it gets a little wacky. He argues that since a laser beam is projected and flies through the air, it qualifies as a missile. The applicant did not, unfortunately, have any legal authority or case law to back up his claim that a laser beam is a missile.
Have you heard of physics?
I don't know if this adjudicated that. I think maybe a little bit more evidence on
hurling photons, I guess. Yeah.
It's got a Star Wars vibe to it, right?
I really like the thrust of that argument.
I knew you would like it. I knew when I saw this, I was like, Hamish is going to love laser beams as missiles, space, the Star Wars defense system, all this stuff. So that was one of the arguments that the applicant advanced. The last argument that the applicant advanced was that they relied on a different case that involved, this is another crazy one. So they referred to a previous case in which a pedestrian was hit by an egg that was thrown out of a moving vehicle and it hit them in the eye. Okay. It just, you got to love law. You can't write this stuff, right? And so in that case, the court ruled with the plaintiff because they said the egg was traveling a lot faster than it would have been had they just thrown it at them.
Yeah.
I don't know. Maybe it would, maybe it wouldn't. If it was
I
only
guess
going in
depends
that
how.
case,
Yeah, no, it would have done for sure.
well, an MLB pitcher throws 100 miles an hour.
Yeah, plus the velocity of the car.
I guess so. So in that case, the court concluded that only by speeding did the driver make the plaintiff's injury more than it would have had they just gotten out of the car and thrown the egg on foot.
That's the right. That's the only answer. That's completely right.
Okay,
I like that.
good. So we've heard from the applicant. We're going to now go to the insurer's position. Okay, the insurer says the injury was caused by a deliberate intervening act and not by the use or operation of an automobile. The insurer also said that the operation of a motor vehicle did not cause, contribute, or directly lead to the injury for 4 reasons. There was no collision and no inherent risk to the ordinary operation of a motor vehicle. There is nothing about the movement, mechanism, or function of the automobile that contributed to the injury. And the applicant's vehicle did not malfunction, collide, swerve, or interact with the laser in any way. This is just the injury to the eye as a result of the laser. And then finally, they said the cause of the injury was purely the other party's deliberate conduct, not the characteristics of vehicle operation. And the vehicle's operation was purely ancillary to the injury. So those are the facts you have to work with. I'm just going to call up the conclusion in a separate document so that Hamish doesn't see it in our notes. What do you got? You got any questions? You got any thoughts? Let's hear the thought pattern you're going through on this one.
Okay. So, whether the incident resulted from the ordinary and well-known activities to which automobiles are put. That's the purpose part. I want to say yes on the purpose part because I think they're both in cars. One's doing Uber Eats and the other one is signaling to the other person. I kind of think that just does fit at that stage.
Okay, you are correct. I'm going to give you that part.
Okay.
And here's the finding of the tribunal on that effect. They said that the but-for test is satisfied in that the ordinary and well-known use of a motor vehicle because he's delivering food while the other person was sitting in their car. And so you get that. So
okay,
on to the second stage.
The causation test requires a determination of whether the use or operation of an automobile directly caused the impairment. The laser beam is not projected by the vehicle in any way. It's just by the driver who brought a laser beam into the car to use it as a signaling device.
Great point. If he flashed his high beams at him,
right,
it's a different case.
Yeah, which
maybe would have been a wiser choice.
Yeah.
Right?
Almost like the obvious choice.
Right. One would think maybe there's a part of my car that I could use to convey who I am to this
And then
person.
this guy would get coverage too. Everyone would win.
Yeah.
Okay. So I think it fails on causation because I just don't on the causation part of the test because I don't think the operation of the vehicle was just related to the impairment here. Like I don't think the fact that he was in a vehicle had any causal relationship to the injuries he's complaining of.
You win. Let me quote directly from the decision here. I find the shining of the laser was an unexpected event and it was an intervening act. I find the use or operation of the automobile was not the dominant feature of the applicant's injuries. Rather, it was the shining of the laser into the eye of the applicant. So that is a win for you. Mm-hmm. Well done.
I don't know if that was an easy one or a hard one. I can't really decide because
it was a crazy one.
There's a lot of crazy stuff that goes on in terms of, and we say crazy, like, to be clear, we're not disparaging it. What we're saying is...
Right, I'm not, yeah.
Yeah, like, we're not saying the decision's right or wrong necessarily. It's just that this benefit scheme really is designed to be inclusive. because we want to make sure that if something can be reasonably tied to the use or operation of a vehicle, that someone has benefits available to them as a safety net.
Yeah,
So,
I wouldn't have wanted to be the adjudicator on this one because I think it can go either way, and I'm sure there's listeners out there going, "That's insane!" Like,
mhm,
obviously, they shouldn't get insurance benefits from a laser to the eye. Like,
yeah,
I don't know, but I could see it going either way. I do think, like you, that this is the correct finding in this case, and that it
mhm.
would have been different if they flashed the high beams or if the lasering had resulted in a swerve of the vehicle and hitting
And
a
then a
parked car.
collision.
That would definitely qualify.
Hmm.
Um, but just being lasered in the eye, I don't think is a operation of a motor vehicle
Right.
issue. So
What's
there we have it.
I mean, I like, the insurance position I like because it's very straightforward and kind of like, guys, come on, this is not use or operation of a vehicle, but I do respect the applicant's argument,
Oh, the
and
missile thing about lasers being a missile.
I I
With the
th-
right use of a grade
I
12
th-
physics textbook, they might have been able to pull that one off.
I think it's creative lawyering and it should be commended.
I do too. I have to say I respect going for it like that.
Hmm.
And not everybody would, and we should. We should take and advance all available positions for our clients, and that was good lawyering on their part.
If you've been injured by someone shining a green laser beam in your eyes while you're attempting to deliver food.
Yeah, call Hamish. He's going to sort you right out. He knows the law. Oh, so there were a few other cases in there I didn't reference because I want to save them for future episodes. It was a zany decision. There's all kinds of fun stuff in there. The egg thing was crazy too. So, what can we do? On to the thrust of this episode.
Mhm.
Contributory negligence. Hamish, what is contributory negligence?
Contributory negligence is when you're involved in an accident and blame is assigned to the other party, but there is also a weighing of whether you played some role in causing your own damages. Like, were you partially or completely at fault for the injuries and losses you suffered?
That's right. So, whose fault is it? Is it also your fault
Hmm.
as a plaintiff? Just because you're the person who brings an accident claim or an incident claim, it doesn't mean that you are automatically not at fault. The court's going to do an analysis about who's at fault.
Yeah, and uh, it's assessed as percentages. I think I always like to emphasize that the step one is the defendant negligent? You look at that in a vacuum first.
Correct. Yeah.
Are they liable? Are they negligent?
Is there something they did or did not do that caused this
Hmm.
incident to occur?
Now, at a later stage, then you then assess, did the plaintiff contribute to their own losses?
That's right. And I have to say, these are not that we don't sympathize with our clients who have been through injuries. Obviously, we do, and we take that very seriously. But these can be some of the most interesting and fun to work on
Hmm.
cases because you got to think, you got to do a lot of thinking, creative thinking. Sometimes you got to get experts involved about standards of care and things like that. And they're
Hmm.
not the sort of run of the mill type of claim that you don't have to think as hard on, right? On a rear end accident,
Yeah.
if you're on for the driver who's been rear ended, they are not going to be contributory negligent in almost, I can't think of any situation really where
Hmm.
a parked car that gets driven into from behind is at fault. So those don't have the same issues that we have to put our thinking caps on for.
And I will say that they're very difficult cases because I find it quite taxing to explain to a plaintiff and a client. It's really difficult to say, there's this concept called contributory negligence. You can also be found at partially at fault, and that will serve as a discount on whatever damages you may otherwise be awarded. It's just difficult to say that, there's a risk here that a trier of fact will find that you are partially at fault, because I think it almost, like, it kind of hurts to be like, well, I'm at fault for this horrible thing that happened.
Right.
And
I got hit by a car. How could I
yeah,
be at fault?
and I think while it comes from moral blameworthiness, technically, like if you look through the history of it, I think really legal fault in these cases is kind of a slightly its own thing. It's not like ethical fault, really. It's like,
Yeah. And whether anybody will admit to it or not, there's often some legal gymnastics, I'm going to call them,
Yeah.
that people will go through, not just judges, but the lawyers involved on cases will go through some legal gymnastics to try and find fault, especially if there's a party that's insured that
Mm-hmm.
at first glance might not appear to have done anything wrong.
Mm-hmm.
And then there's a party that is not insured, and they have been the person who's done the most of the wrong. They might find some contributory negligence on the part of the insured party, and then their passenger will get access to those benefits because they've found something, right?
Yeah.
So that's a factor that's out there. But what are some of the cases that we typically see these allegations of contributory negligence on?
So the ones I've worked on more recently have been pedestrian collisions and slip and falls, but I understand that you've more recently and historically seen a lot of left turn on green light cases. So this is um people do them countless times a day. You imagine anywhere you're driving in the downtown-ish core or out in the suburbs where there's a big four-way intersection, you have a green
Arrow sometimes.
yeah, sometimes a green arrow, but let's say it's not a green arrow, and you make the left-hand turn, and someone either goes straight through and hits you and doesn't give you that room, or you went a bit too quickly, or you thought there was a gap and it wasn't there. So these can be very tricky because it's often, it's often a situation where really both people could have avoided this collision happening, and it's very fact specific in terms of how that fault determination will break down.
Yeah, we see every left turn case, I would say, even the ones where there's a green arrow involved, have some allegation of contributory negligence, and
Mm-hmm.
that uh, when it boils down to it, you still have to make sure that wherever you're driving your car, you're doing so as safely as you can. And so if you see that there's somebody coming at you at a high rate of speed, um, and you're not sure that you're going to be able to complete that turn safely, whether you have a green arrow or a green ball,
Mm-hmm.
if the light's gone back to red and you're blocking the intersection, but you need to complete the turn, and there's a risk that
Mm-hmm.
the coming vehicle coming at you might run the red. Yeah, all that it's really tough to do. I don't blame
Yeah.
anybody for the choices they make, right? These are split second decisions that you have to make, but it's a big issue about how much a fault can be apportioned to each party. And
Yeah.
on large cases at high speed, it can be hundreds of thousands of dollars in difference.
Yeah, and it really, because out of a lot of the things we do in regular day-to-day driving, it's almost the one where it's kind of the most discretionary, but also the highest obvious risk, being you're turning across a live lane of traffic that also has
A
right
right
of
of way.
way.
Yeah, yeah.
So,
These are sometimes the most violent collisions we see.
yeah,
Yeah.
big closing speeds, and especially like it's often like a 70 or sometimes an 80 or something like that. Both vehicles in motion and the angles involved, they can be pretty major, and going to trial in these cases it's risky.
Yeah, and that
Um,
left turning vehicle is often in the path of the vehicle going straight for a long period of time because they're going from a standstill or a
mhm,
very slow speed. So it's not that there was a half-second window where this accident could happen. There's like a 3-second window sometimes
mhm.
where they can still get struck. So we see it a lot on those cases.
Yeah, and also the breakdown in terms of the options of what the plaintiff otherwise could have done. They could have accelerated faster to make the turn.
Right.
They could have not accelerated for the turn. They could have braked earlier. They could have swerved to the right. They could have swerved to the left. They could have swerved in any which direction. So,
Stay
um,
put.
stayed put. Like there are so many different things that can be that a competent defense counsel can suggest that they could have done other than what they did do, which was keep turning and make the to try and make the turn and then get struck by the car traveling towards them.
Yeah, and then what do you do if, let's say, the car behind the car turning left vigorously honks at you to
Right.
get going and make that left turn, and you're panicked and you make the left turn and then cause an accident? What about that?
Yeah, or you think you're going to be rear-ended, so you felt like you had to go.
Yeah.
So they're very tricky, and what type of, I mean, a lot of these cases don't end up going to trial because they're risky
Right.
and the issues end up resolving. But, pragmatically, the contributory negligence is okay. If we're negotiating or we're in front of a tri-fact, it's like here's the damages. Hopefully, we can get some alignment on what the damages are. Often not, but this is what we're claiming for damages. The defendant's negligent. Now, turning back to the plaintiff, what percentage were they at fault? And that percentage is just a reduction on the damages figure.
Yeah. It's just whatever percentage is applied to them for contrib comes off the top. Is it 10%, 15, 25, 50? Who knows? So those are left turn cases. I want to talk a little bit about the pedestrian cases as well. And you've had some files of late. I think we both have some pedestrian cases. But why don't you tell us a little bit about what are the ideas in mind and the law about pedestrian strikes? So this is where a pedestrian's been hit by a motor vehicle.
Yeah, so pedestrians are generally under the Highway Traffic Act. If they're in a collision between a car and a pedestrian, there's a reverse onus.
What does that mean?
So a reverse onus is basically flipping the script. So basically, instead of the plaintiff having to prove, hey, I was crossing the street, I was hit by a car. This is how I prove that you were negligent, defendant driver, for hitting me. How could you have done that?
Right. And that's the usual thing that we
That's
have to do. The plaintiff has the onus of proof of showing that the other party was responsible.
right. And in a reverse onus case where a pedestrian's hit by a car, the defendant has to proactively prove that they were not negligent. So it's basically, well, it's flipping the burden from one side to the other. So the plaintiff can, pragmatically, it changes the risk calculation. It doesn't mean that these cases unfold in a radically different way.
Yeah,
But
I think it sounds more important than it is.
Yeah,
we still do the same analysis.
Because you're still not going to rest on your laurels as a plaintiff. You're not just going to say, oh, I have nothing to do. You're still going to go out of your way to make it, to corral the evidence to make it clear that the defendant was negligent and they did fail to act or they acted unreasonably. And you're going to pursue every avenue possible in that respect. But at the end of the day, the risks are just more stacked against the defendant because proving the absence of negligence and having that burden is very difficult.
Right. So in a case where, let's say, a pedestrian's crossing at a four-way stop sign and they're hitting the intersection, I think that's pretty cut and dried. That's going to be 100% on the driver of the car.
Mm-hmm.
Where do we see things get a little bit different?
So it gets tricky when you're not at an intersection or not in a crossing.
Or in a crossing, but you don't have the walk sign.
Yes, that too. So if you're crossing against the traffic signals,
or
jaywalking, or crossing not in an intersection, that's when it's a bit more tricky. And unfortunately, where it becomes especially tricky is when, a lot of the fatal accidents we see are car versus pedestrian accidents because obviously
pedestrians don't have crumple zones and airbags.
Yeah. So, and the issue presented there is now you only have one person alive to tell the tale. So if they say, I had a green, it's very hard to disprove that if you don't have solid engineering evidence,
video surveillance,
other
eyewitnesses.
It just becomes tricky.
Well, it's super hard if you're on for the deceased and their family, and how can you possibly prove whether they had a walk sign or not?
Right. So that's where it comes up, and then also another tricky situation is when someone's jaywalking or crossing not at an intersection, because there is, even with the reverse onus, if you're not crossing at an intersection, the reverse onus does not mean that you can't be found contributory negligent. You can still be found to be partially at fault for your own injuries if you're crossing not in a designated crosswalk. And a lot of the time, engineering expertise is needed, and things like if it's at night, what clothing were you wearing? Were you wearing dark clothing? Were you wearing light clothing?
Yeah,
Were you
high vis
wearing
jacket.
high vis jacket?
Or so my wife goes running a lot of the time in the very early morning before the sun comes up in the winter, and she has a full on light up vest. Like it plugs in to charge overnight, and it's very visible.
Yeah,
You know.
really smart thing to do. It's not worth taking risks with that, but yeah, we'll see experts go out to the field and take assessments of lighting conditions on comparable nights with comparable cloud cover and at the same time, so they can come up with an assessment of how good are the lighting conditions on the ground. There'll also be, there'll be factors about um, intoxication,
Yep.
uh, di- other avenues open to someone. So if there was a crosswalk really close by and someone elected to 12 feet away cross behind a parallel parked car that partially obscured them entering the roadway and then ran out in front of the traffic, then yeah, someone could certainly be found contributory negligent, even when there's a reverse onus.
Yeah. Well, I think we see a lot of these for a few reasons. Number one, people crossing in crosswalks are automatically a lot safer because the cars are expecting you to be there.
Mm-hmm.
So they're less likely to have an accident when you're crossing at a crosswalk and when you're crossing with the right signals. I mean, it just doesn't happen as often. Where it does end up with us is somebody's crossing when they don't have they're jaywalking, they're darting through traffic. We see it a lot in the downtown area.
Mm-hmm.
Traffic's either moving very slowly or um, there's just a lot going on, so that people will just go across the road whenever they want, and they won't necessarily have done it in the safest possible way.
Right.
So that's where we see these accidents.
Yeah, and they can be tricky. They're not. They often, as I said, it comes down to witnesses, video, and whether or not you can find a good engineer and whether or not there's a credible alternative version of the story to what the driver's saying, especially when it's fatal. But
For sure. Yeah.
uh,
Just the last note on we got one more area I want to talk about with contributory negligence, but a last thought on the pedestrian issue is, I think there's some parts of town at
mhm,
certain times of the day where it's going to be a higher burden on a driver. And my example would be if you're in the Byward Market and it's 2 in the morning
right,
and everybody's spilling out of the bars and clubs that they've been to, and it's Saturday night and it's full of people walking around in various states of intoxication. As a driver, you've got to be very alert to the possibility that anybody at any time could wander into the street in front of you. And I think the onus in that situation is a lot different than it is on
Merivale Road.
at 2 in the afternoon
Yeah,
on a Wednesday,
right,
right? Like there's sidewalks there, there's intersections that are governed by traffic lights. You're not expecting people to just stumble into the road.
right.
So I'm not
Yeah,
saying you can't look. You do have to look, right? If you see some people on the side of the road and maybe they're walking erratically, regardless of where you are, you should be safe about it. But I think that it's a higher presumption in certain parts of town at certain times of the day.
yeah, definitely agree with that. And so the third area we want to discuss for contributory negligence is slip and falls.
Right. And this is a very popular area for defense folks, and we've been those people
Yep.
making these arguments to say, well, you slipped and fell, but it's not all my client's fault if you're on for the defendant. What are the
Right.
sort of things they say?
Well, when there's snow and ice slip and falls, a lot of the time it's what footwear were they wearing? Uh, did they? I think knowledge of the conditions to me is something that I think is kind of more persuasive.
Yeah,
But
I think the classic argument of you got to look where you're going
yeah,
is a factor, right? Like if there's a very plain and obvious defect in the sidewalk or snow or ice pileup or something, and it's very obvious to be seen. I'm not saying that that person's 100% at fault. They're not, but you got to bear some responsibility to look where
right.
you're going.
And then there's, I guess, high heels in freezing rain.
Yeah, a classic combination.
A classic combination. And then there's the what were you holding in your hands? Are you?
I don't buy this as like a valid thing. It gets alleged for sure.
I know.
But like, is it negligent to walk with a cake to your car from the bakery? I don't
Right.
think it is.
I know.
You know?
The slip and falls is a weird one because there's how it gets discussed and pleaded and how the actions kind of proceed. But I agree with you. I think you can carry a lot of different things in your hands, and it doesn't mean you're negligent at all for falling over a huge crack in the sidewalk that was
Yeah.
just wrong and shouldn't have been there. You're allowed to carry things.
Yeah, you're allowed
But
to move stuff and carry things. And let's say you've got a big dolly full of boxes and you can't quite see where you're going. I don't know, maybe there's something on you for, not pre-checking your route, but I don't buy it. I
yeah,
really don't. I think like if there's a big hole in the road or a crack in the sidewalk that's so large that it
right.
causes you to fall over, that's on the city
Now,
or
intoxication, I think, is a pretty. I think
yes.
that's a pretty valid one. If you're falling down a flight of stairs because you had too much to drink and the stairs maybe had a chip in them or are deficient in some way, that I would be cautious about that if I'm representing a plaintiff and I thought that alcohol was a factor in this. I think that's a solid defense argument.
Yeah. Or if you live in a building and you've lived there for years and you always know that you got to skip a step or
Mm-hmm.
walk around this obstacle that the building's just never fixed, but you are
Right.
very, very, very aware of it. And that on that particular day, you decided to do something that wasn't in your normal routine,
Right.
maybe there's some contrib there.
Yeah. So again, it's a fact specific thing. In slip and fall cases, I feel like the contributory negligence part usually isn't that high.
No, it's
Like,
always thrown out, but I don't think it's ever really a barrier to settlement.
yeah. And again, the fact specific is you come in and out of this building every single day. You know that there's a crack there on that particular day. You slipped on it. You've been living there for 20 years. I mean, that's kind of more significant.
Yeah.
But if you've just landed in Canada from Australia, you've never seen snow before, it's your first time in this specific building, and you slip on the poorly shoveled staircase, then maybe there's no contributory negligence.
Yeah.
I'm not sure.
Yeah.
Okay. Well, I think moving on from that, I think that about wraps us up. So, where can you find our team,
Well,
Stan?
you could find us on nelliganlaw.ca. Just Google Nelligan Law. It'll bring us right up.
On our wonderful new website, and you can find me on LinkedIn at Hamish. Sorry, LinkedIn.com/IN/H Mills McEwen.
Same thing for me, just with Stanford Cummings and replacing H. Mills McEwen. If you have any comments, questions, topic suggestions, please give us a shout, drop us a line, civilbanter@nelliganlaw.ca. If you've got any particular stories that you want to relay to us, if you've got any tales of success that you would like us to share, let us know. Like, comment, subscribe, and thanks for listening.
Okay, thanks. That's a wrap.